Namaste, welcome. Good morning good evening to all of you. Today we're going to talk about a very important subject. Last year in July, the Maharashtra Assembly passed a bill called the Maharashtra Special Public Security Act of 2024. We're going to discuss that with its legality and impact with the two legal experts, with Dr. Swamy and Dr. Venkat Iyer. But before we get into the show, we have a practice of talking about freedom fighters uh, who are not very well known. So in that series, we're gonna talk about Rajmata Jijabai. So and uh, we will show, basically she was born in Sindh Kedraj in Jijamal in the present day Buldana district of Maharashtra. So we're going to learn a little bit more about her and her sacrifices.
Born in 1598 at Sindhkhed Raja in present-day Buldhana district, Rajmata Jijabai was the daughter of Lakhuji Rao Jadhav and Mahalasabai, members of a prominent Maratha noble family serving under the Nizam Shahi Sultanate. At a young age, she married Shahji Raje Bhosle, a distinguished military leader serving under the Adil Shahi Sultanate, setting the stage for her pivotal role in shaping the future of the Maratha Empire. Growing up amid constant warfare, the oppression of Hindus, and the fragility of local kingdoms, Jijabai developed a deep understanding of the need for an independent, strong, and principled Maratha rule. Known for her fierce dedication to her people in the vision of Hindavi Swarajya, she shaped the character of Chhatrapati Shivaji Maharaj, instilling in him courage, discipline, patriotism, and a commitment to moral governance. A woman of vision and strength, she combined strategic insight with fearlessness, serving as an efficient administrator and a moral pillar of the Maratha cause. Her unwavering devotion to Dharma, her people, and the ideals of Swarajya earned her the revered title of Rajmata. Today, we honor Rajmata Jijabai, not only as the mother of a great king, but as the courageous spirit and guiding force behind an empire, whose legacy continues to inspire generations.
With this, we go over to Dr. Swamy. Dr. Swamy, the format is you're going to speak briefly, give us an introduction, then Venkat can talk about it, then can have a discussion. Dr. Swamy, over to you.
Well, first of all, this law, which is not yet, I think, passed finally, but it's on its way. Maharashtra, a Special Public Securities Act, it's called, 2024, and its legality and impact is the one that we are looking at. Now, the arguments in the assembly and so on was that to provide a more effective preventive unlawful activities of individuals and organization, and for that matter connected with the same. So section 10 of the law, the proposed law, makes it possible for a district magistrate or a commissioner of police to take possession of anyone and his properties. So it's a very draconian sort of thing where there's nobody who's required to produce a information or to show that the police has got it wrong and so on. So it's a thing that we have to now look at it from that point of view, and that's why we have taken this matter in this case. Now, if you look at the statements and objectives of the law, which is very crucial in any law that is passed, it only says that it is for the fighting the menace of Naxalites. But it is now being seen that action is being taken against everyone who is not even a Naxalite or not even remotely a Naxalite. So I think we must insist on the Maharashtra politicians that they should either amend it or they should or they should scrap it so that it can be done again in a different way. So in that context, we have assembled today. A lot of people, all of you have a knowledge of these things from many angles in many cases. So therefore, over to you, and let's get on with it,
Mhm.
and describe whether this law to be made is actually as dangerous as I'm making it out to be, or it is just nothing more than what we have been having, like previous laws brought in, and just a way of scaring some of the people and leaving all others untouched.
Okay.
Over to you.
Thank you. Thank you, Dr. Swamy. Before I
Yeah.
bring Venkat on, I should thank Tejas for bringing this to my attention because Tejas saw this right after the BMC elections were announced. He brought this to my attention, and when I read it, I just fell off the chair. So I thought this is worthy of a discussion on this platform, especially since we also have a legal Gyan Ganga series, and that's what I thought this would be a very appropriate point to bring this topic up. And obviously, Dr. Swamy, who better than you from a constitutional standpoint? And we will now hear Venkat, his views, and then we will go into the legality and impact of this in a more, we can discuss that a little bit later. Over to you, Venkat.
Thank you, Ramesh, and thank you, Swamy, thank you, Arvind, and thank you, the technical team, for all the great work you're doing. It's a pleasure for me to return to Gyan Ganga. I'll try to be brief. I'll probably speak for about 10 to 15 minutes. We are dealing with a worrisome law. Before I offer my analysis of it, I think it would be helpful to recognize some basic realities so that it doesn't appear as if our discussion is based on naive or unrealistic assumptions. Firstly, every country needs to protect vital interests such as national security, public order, etc. And this means that there will have to be laws which allow for a curtailment in individual freedoms to accommodate those interests. Secondly, the menace of terrorism, including what is referred to as Naxal terrorism, is a real one, which can and has been shown to cause great havoc, including loss of lives. Therefore, a reasonable case can be made for dealing with that menace. Uh, Indeed, it would be a dereliction of duty on the part of any government to ignore the dangers of terroristic violence and other unacceptable actions. The question that then arises is, does any response contemplated by the state strike a fair and reasonable balance between, on the one hand, ensuring that law abiding citizens enjoy the rights and freedoms they are entitled to in any polity that is governed by limited government and the rule of law, and on the other hand, preventing and punishing serious harms from terrorism and other similar conduct. Some guidance on how this balance is to be struck is offered by the Constitution, which wisely guarantees various freedoms while making such freedoms subject to clearly defined limitations and qualifications. Obviously, no constitution can be exhaustive in listing all the harms that a society may be exposed to, nor can it be overly prescriptive in the kinds of steps that a government may take in dealing with them. A crucial element in all this is the role of the judiciary, which is seen as an independent arbiter between the citizen and the state. In the absence of a judiciary that is independent, efficient, effective, and non corruptible, we can kiss goodbye to all legal and constitutional protections. A point which I want to emphasize and which I may return to later. Now, against that background, let us look at the law we are discussing today. It is not easy for me to ascertain the exact current status of this law because there was very little in the public domain about what has happened after the law was passed by both houses of the Maharashtra state legislature sometime, I believe, in mid 2025. All we knew was that the bill, as passed, was referred by the state governor to the President of India for her views after many civil liberties organizations had expressed concerns over its provisions. But further research has revealed that the bill was given presidential assent on the 10th of December 2025. There's a certain irony in that date because it also happens to be World Human Rights Day. But we'll put that to one side. Now, this means that the law is now fully enacted. But I have not been able to ascertain if it has been brought into force yet. Now, as many of you know, this is done through an executive act by the state government. What are the key worries about the law? Broadly speaking, we could characterize them under 3 or 4 broad heads. Firstly, that some of the definitions provided in it are overly wide. Secondly, that too much power is vested for its implementation on relatively low level officials. Thirdly, that not enough oversight is allowed by the judiciary over executive actions. And I would add, fourthly, that some of the harms being sought to be addressed can be dealt with through other existing laws. If I were to turn to specifics, the law makes it an offense to, for example, say or do anything which constitutes a danger or menace to public order, peace, or tranquility. The law also says it will be an offense to do anything which interferes or tends to interfere with the administration of law or its established institutions and personnel. Furthermore, it makes it an offense to do anything that encourages or preaches disobedience to established law or its institutions. Now, many would argue that some of those acts, if carried out peacefully, are part of democratic dissent in any free society. India has a rich tradition, as many of you know, of what is called civil disobedience, something that has been lauded for the part it played in gaining the country independence from British rule. I would argue that the dividing line between acceptable and unacceptable conduct should be a tendency to cause violence, which should be judged on the basis of a clear and present danger test. More generally, if there was an efficient and effective police force, that force should be able to deal with any so-called menace and other similar threats to public order, peace, or tranquility. Or to take another aspect of this law, speech or acts which interferes or tends to interfere with the administration of law or its established institutions This is, I would argue, covered squarely already by the law on contempt of court, subject, of course, to the act in question reaching a certain threshold. But it needs to be emphasized that the law of contempt comes with some safeguards, which this law lacks. And that means that under this law, there is potential for abuse. If you want to be more technical, you can look at the loose definition provided in the law of what constitutes an unlawful act, namely, anything that may cause danger or menace to peace or tranquility. Such acts can only constitute localized disturbances. A law and order issue which is far short of presenting a threat to public order. That is to say, wider disturbances that affect the community at large, which is the threshold prescribed under the Constitution for imposing reasonable restrictions on fundamental rights. This is only one illustration of the overbroad definitions provided in the Act. It's not difficult to imagine many situations which most people would consider to be a part of expression of democratic dissent, but which would lead to punishment under this law. For example, let's say that an amateur dramatic society in a college stages a satirical play against police corruption or police high handedness, and which calls upon everyone to stand up against such corruption or high handedness. A hypersensitive administration is likely to respond with a prosecution holding that the play has encouraged or preached disobedience against established law and its institutions. Such examples can be multiplied. The risks of questionable prosecutions are very high indeed, especially if you consider the alacrity with which cases are brought in many places. Another worrisome feature of the law is that there is not enough judicial oversight. Actions taken by the government, for example, to designate an organization as an unlawful organization, which in turn can lead to punishment against its members, are only to be overseen by an advisory board whose members may not be truly independent from the government. There is no requirement that the advisory board members are judges, whether sitting or retired. All that the law requires is for them to be qualified to be appointed as a judge of the High Court, which means that any lawyer of 10 years standing can be made an advisory board member, and the government could, of course, seek out pliable lawyers for the job. The effectiveness of the advisory board as a safeguard against arbitrary action is further undermined by the fact that its reports on, for example, whether the designation of an organization as an unlawful organization need not be published. This militates against any form of transparency and accountability. If the task of ruling on the correctness of such designation had been entrusted to the judiciary, there would have been a verdict delivered in open court, as should be the case in any democracy. Questions can also be raised about the rank of the officials who are empowered to take decisions under this law. For example, an officer of the rank of sub-inspector or above may undertake an investigation. This is a lower threshold than in corresponding laws, where I understand it has to be at least an inspector or above. Or if you look at another Maharashtra law itself, the Control of Organized Crime Act, I'm told that it is a deputy superintendent of police who can take action. By allowing lower rank officials to take far reaching decisions which have serious consequences for the individual, there is a risk of abuse of power. Um, Before I end, I want to make a general point of importance. It has to do with my belief that even where there are faulty laws or imperfections in the implementation of laws in any country, the situation can be saved if there is a functioning judiciary that is both efficient and vigilant. That, alas, is a statement which cannot be made with a huge amount of confidence in the India of today, which I consider to be a great pity. Thank you very much.
Dr. Swamy, your comments, and then we can go to
some questions that I have to ask him. First of all, they say unlawful organizations in the writings of the law, and that means a state government can declare any organization unlawful if its activities are deemed a menace to public order or tranquility. It's very vague. I mean, it can be done to anybody, including you, me. Then you have some broad definition. There's, of course, dealing with the unlawful activity, etc. But when it comes to offenses and penalties, a membership, being a member of an or attending a meeting of an unlawful organization is punishable by 3 years and 3 lakhs.
Yep.
If you just attend it.
Yep.
And financial support, contributing to or soliciting or for such a group carries a term of 2 years and 2 lakhs as fines. Finally, the planning or committing or planning an unlawful activity is punishable up to 7 years and 5 lakh. Now, do you think that have you seen anything parallel to this kind of thing? You see, just you are there. Exactly. So this is what needs to be brought out. I mean, and it's a BJP government, Maharashtra. You see, and they passed it out.
Particularly worrying is the lack of judicial oversight. Now,
That's right.
I'm not going to put too much faith in the judiciary, given what we have seen in recent months about the extent to which the judiciary has been willing to protect fundamental freedoms. But there's a very good possibility, because remember, there are some good judges even today. And it is possible, at least if the law allowed for judicial scrutiny, that the situation could be remedied. But for this vague wording to be coupled with lack of judicial scrutiny is, according to me, a recipe for disaster.
Yeah, we are all BJP people here, and it is the government which is BJP, which is making us all very bend in the public eye.
Yeah. Yes, Ramesh. Sorry, you're not audible.
I'm sorry, I had muted. Okay. In the unlawful activities, Dr. Swamy, there is one line that number 7, as Venkat, you also alluded to. It says, encourages or preaches disobedience to establish law and its institutions. Isn't that the basic fundamental right?
In democracy.
You can say if the government is wrong, saying that you're wrong, and say if you're wrong, we will protest in the street. So they can arrest and for 3 years and 3 lakh fine for just disobeying or disagreeing with the government, Dr. Swamy. That isn't that itself so vague? But your thoughts on that, Dr. Swamy, and involves collecting and as one very important point, Dr. Swamy, even if I remotely support an organization, not even directly getting involved, I don't have to attend a meeting. I just said, hey, they are doing some cause.
Correct. Yeah.
So, for example, Dr. Swamy, this can come back and bite RSS. I'll tell you why. If this law continues and tomorrow Congress government comes in there, they can say the RSS is such an organization. What prevents that government from declaring RSS such an unlawful organization? Nothing wrong, right? I would have contributed for another cause, say flood relief for that organization, but I am still liable according to this law, and they can throw me in jail for 3 years or 3 lakhs. Fine.
Yeah. I think the best way is not wait till the BJP comes to power. I mean, the BJP is out of power. But the fact is that I think we can make a case in the court of law. And I'm already consulting with my people. And see that all these things which are so vague have, the government is told by the Supreme Court, go and finalize your all the conditions that you have put, and see that and explain to us how the democracy's basic fundamental rights are protected. And these are ways where the people should do. But nowadays, even lawyers are afraid to go to court, saying that they'll be chased, you see, by the government of India, or they will not get good law, an opportunity to represent the government and make a lot of money. So, I mean, we are in a situation where democracy itself is in danger.
Yep.
I have one more point. Unless Venkat, do you have anything else? I have one more point to ask.
No, Ramesh, you go ahead.
Okay, so I'm not a legal guy at all. So, but I did, thanks to ChatGPT and the world that we have today, we are able to do research much faster than even Google. So, Dr. Swamy, in that, one of the things that was brought up, so I don't know its validity, but I'm asking you this question. It says, if under Article 19, 1A and C, right, the freedom of speech and expression, and that's what it talks about. The bill assumes that the individual may be punished for the membership of, even if I'm sympathetic towards that organization.
Yeah,
right.
That's right.
And in one of this research tells one of the Supreme Court case of Kedarnath Singh versus State of Bihar, 1962, opined that the criticism of the government or articulation of political ideologies, however radical or dissenting, will not constitute sedition or illegal action unless there is incitement to violence or intent to create disorder by that particular individual. But the entire thing is being construed to be anybody can be, even if you're a supporter remotely, you can be charged under the law. So that is one. There's another one, again, another case that is mentioned here. It says the Modern Dental College was the state of Madhya Pradesh, 2016. The court restated the doctrine of proportionality, by which limitations on fundamental rights have to be necessary and least restrictive means of achieving the legitimate object. So with this, Dr. Swamy, at least on Article 19, do you feel that there is a direct impact? Since we're talking about impact and legality, what are your thoughts on this particular bill impacting Article 19?
No, of course, the Article 19 is basic in our Constitution. That's where the freedom is given real power. All the others, 20, 21, these are things which, just add on to it. But the real one is Article 19. And Article 19 has been literally sabotaged here. Now, I am quite surprised that nobody is getting up in the so-called liberals and saying, no, this must be stopped. There's no demonstrations. No one is giving a call. And most of the people privately say, Swamy can do. He's a BJP and the BJP people don't want to touch him. So therefore, he can say what he likes. That's all nonsense. You get that kind of a reputation only if you are ready to fight unafraid. So I think this particular thing should be now challenged. And I'm working on it. And I hope in another month I should be able to give you a Gyan Ganga
Mhm.
exactly what we are about to do or what we have already achieved.
Okay. So, Venkat, this next question is for you, and then I'll leave it up
Yeah.
to Arvind because
Okay.
Arvind has got some new breaking news as well. So,
Yep.
according you, we talked about fairness, right? No judicial overview, how this board can be formed at whim and fancy. So, the bill, if you like, look at Article 21. I mean, it just says there is no fairness. The bill criminalizes offenses under the Act as cognizable and non-bailable.
Yep.
Most important, just by being a supporter, it's a cognizable and non-bailable offense. Gives the government immense power to confiscate property, assets, whatnot, that belong to the unlawful organization. What is alarming, Venkat, is that such these penalties can just pile up without any
Yep.
judicial precedence, oversight, control, nothing like that. I mean,
Mm.
in the again, one of the research tells me, Dr. Swamy, in Maneka Gandhi was Union of India, the Supreme Court ruled that a law encroaching upon individual freedom shall have to be just, fair, and reasonable, and not arbitrary or oppressive.
Yeah.
Doesn't this bill fly straight into the face of this judgment, Dr. Swamy and Venkat? Your
Yeah,
thought?
somebody has to challenge it. No, if the
Hmm.
government says to hell with whatever passed earlier by the Supreme Court, we are not on it. If somebody is unhappy, let them go to court. So ultimately, we'll have to go to court. We'll have to stand up and fight it out.
Venkat, your thought
Yeah.
on
Yeah.
this?
Absolutely. I totally agree. And we are now one step closer to the possibility of challenging it in a court because fortuitously, late last night, after Ramesh and I spoke to each other, I discovered that the bill has actually been granted assent by the president. In fact, I confirmed it also by going to the Rashtrapati Bhavan website, and it says very clearly that assent was given on the 10th of December. They obviously did it quietly without giving it too much publicity. So, what that means is if somebody were to challenge it in court, they need not worry about the bill not having been fully enacted, including getting the presidential assent. And I suspect, now this is something I don't completely agree with, but I suspect that it is even possible for somebody to file a public interest litigation challenging the bill or now the act. Although, of course, my preferred way would be to wait until action is taken against somebody and then for that action to be challenged. And I'm convinced that if you had judges who are sensible, vigilant, and willing to stick their necks out, that they can strike down large parts of this law on the grounds of incompatibility with constitutional provisions.
Yeah.
Okay. Arvind,
It's,
you're on. Yes,
it's
go
one,
ahead.
it's one minute. It is called a Maharashtra, the
Special
judge.
Public Security Act.
Yes, but it applies to the whole country.
Correct.
So how can they just simply say, this is only valid in Maharashtra and let the Maharashtrians fight it out? I'm unable to understand uh, all this. I mean, obviously, the BJP government has no knowledge of what law is. You see, they put it in, and there have been other laws also in the past. We have taken it down. So I would say to the Prime Minister, don't spoil your name, don't make yourself a laughing stock around the world, and say that India claims to be a democracy. But, say that this was not shown to me, and I'm having it reviewed, and get it reviewed.
So, Dr. Swamy, what prevents the state of Maharashtra to declare an organization in Tamil Nadu as unlawful and take action on them? I'm just giving a hypothetical question. I don't know the legalities. Does this bill give them, it says only the state of Maharashtra, or can they do across the nation? It's
Don't
not.
don't give them ideas. Huh?
Yes, Arvind ji, now it's your turn. Go ahead.
Yeah. Thank you, Ramesh. Ramesh, first let me just reply to your question about how can the Maharashtra rule be applied in Tamil Nadu. There's a law called Makoka. for against organized crime for terrorists, and this applies everywhere, though it was made for one state, but they say as applied. So the person who is accused could be anywhere in the country, but if the law is passed by one state government, that can also be applied. So they say as applied in Makoka case, this can be applied in this case also. First of all, this law, this has not become the law, yes, yet.
No, no, it has.
Of
It
the
has.
bigger-
It has.
it has not been implemented. It has not been implemented. It's not executed.
Yeah.
If it was
So
executed, even our program in Words of Wisdom, Gyan Ganga, can be
Correct.
questioned
DHS can be declared
a-
one.
yeah,
Don't
as
give
a
them ideas. That's what
criticism.
Dr. Swamy is saying.
Okay,
yeah.
as a criticism. Now, every government, it's not only Maharashtra government, BJP government, or Shiv Sena, every government has this streak of dictatorship or the fascist mentality. From time to time, they have been doing it. Dr. Swamy said that Modi should be aware of the democratic values and things like that. You see, Dr. Swamy, India has a rank of 151 in press freedom. Though we say we have the largest democracy, we have the biggest press, the freedom of the press, 151 is the rank, India's rank in press freedom, and 100 out of 179 countries in democracy. We may be largest democracy, but if we look at the value of democracy or the process of democracy, global organizations have ranked us 100. That means 79 countries are better than us. 100 countries are better than us. Only 79 countries are below us. Number one. Number two, these acts, it's not for the first time. This is basically to control. Power corrupts. Absolute power corrupts absolutely. So they are basically using the power, I would say abusing and misusing the power to control. I'm not sure whether this control is only for the other organization outside BJP. That maybe within the government also there is some kind of dissent, and maybe this can also be applied if the in the political combination in Maharashtra, if some people go against the government or they ditch the government, maybe it can be applied to. So it is basically to scare the people so that they do not protest. When Jayaprakash Narayan in 1975 challenged the emergency, he was very old, and he used to say, "इस नदी की धार में ठंडी हवा आती तो है, नाव जर्जर ही सही, लहरों से टकराती तो है." So there should be someone to protest. Dr. Swamy has, for example, said he is thinking of challenging it. I am surprised till now, even in Maharashtra politics, why people have not gone to court against this. And what about Human Rights Commission? We have a state Human Rights Commission. We have a central Human Rights Commission. No, in fact, these state Human Rights Commission and the central Human Rights Commission, they should have taken suo moto note of this draconian act, which is basically to gag the voice of the dissent, or gag the voice of the protest anywhere. And it is not, as I said, it is the mentality which is break the morale of the people who want to protest or who are against the government. They say anybody who is with us, he is the citizen of the country or the state. Anybody who is against us is anti-national. So this is the mentality that they are doing, and it is not for the first time. In fact, we were discussing UGC has just passed a regulation in the name of equality. And what they have done is also more draconian than this. They say that anybody who goes against, who uses a word against scheduled caste, scheduled tribe, OBC, can be prosecuted. Not only prosecuted, if there is a complaint, and even if the complaint is found to be false, no action will be taken. It is like that SC Act. So this is there. No, I am surprised why Supreme Court or Human Rights Commission are not taking note of these things. There is no bail, Dr. Swamy said. Now this is again to scare people. Your land can be confiscated, your assets can be booked, and you will be nowhere. The way you protest. This government, people have been accusing of only accusing, they're not acting, taking help of ED, CVI, IT against the political opponents. So this is one form of controlling the political opponents, and therefore they are doing it. Similar rules have been formed by different bodies. Ramesh, you were mentioning earlier about the Haryana government trying to control the private universities. I mean,
Yes.
everywhere, it is not only one state. This streak of fascism that we are talking about, that is what which is dangerous, and that should be controlled. And unless people go to the court, Dr. Swamy will initiate, I'm sure, and it will be also get a lot of support, a lot of public support. But those people who are lying down and taking it without any protest are also to be challenged. I mean, they say, what are you doing in Maharashtra and elsewhere? Why are you not protesting? At least in some cases, as I said, in UGC Act, there is a huge protest in Rajasthan, Madhya Pradesh, Uttar Pradesh, from the general category people who are actually the target. But unless there is a protest, the government will not. And I'm not accusing BJP alone or RSS alone. All governments have this streak of fascism. They want to have maximum control possible, and therefore these kind of laws, they have come in the past. It is not for the first time. I remember in 1980s, Jammu and Kashmir brought a press freedom act, and there was huge protests all over the country, and they had to withdraw. So there have been several instances where there has been a rollback, there has been a withdrawal of such acts and rules, and I'm sure if there is a protest, the court will also support.
So, Dr. Swamy, the Haryana bill that Arvind mentioned, it's very what they're doing is they have a private institutions act.
Yeah.
So in there are two sections, 44 and 44A, that has no provisions for dissolution of the board or dissolution of the institution. So they've inserted something, a new one, that is 44B, that allows the government to deem if the university participates in unlawful activities of national security interest, they can dissolve the public institution and take it over. They are claiming is because of this Delhi bomb blast. They've inserted this. I mean, it is just an excuse, Dr. Swamy. So, but it is such a broad term again there, which just says that we have the right to dissolve the institution. The government can take over because it was not existent in the previous act. Dr. Swamy?
We should call to here in this forum Jagga, who is a noted lawyer and also part of our group, yes, and ask him about what is happening in Haryana and in Punjab.
Yes, we can definitely have a follow-up meeting. As you said, Dr. Swamy, we can do it down the line. Dr. Swamy, what I see as a pattern in all of these things that we see today, we saw the UGC thing, the Haryana thing, what's happening in Maharashtra. After the emergency, there were some checks and balances put in place so that the government cannot enact emergency easily. These seems to be unshackling them in small cuts and pieces, put like trial balloons, put it in one state, see what happens, what is the reaction, if there is resistance, no resistance. And one institution after another. First they say, okay, any public social organization that protests against the government, we can arrest them and throw them in jail for 3 years. That is the Maharashtra bill. Any educational institution that goes against, that they deem to be against national security, they can dissolve them and take action on them. And see, again, throw caste-based nonsense again. When this government time and again says there is no caste, Vasudhaiva Kutumbakam, and all this nonsense being perpetrated, this is very clearly a death by 1,000 cuts, Dr. Swamy. There is one party that wants to remain, or rather one individual who wants to remain in power forever, and they don't want to be challenged. But what they don't realize, Dr. Swamy, the other side, if this thing flips, obviously it is going to flip, whether in this decade or next year or this year, nobody can predict. If it flips, the same thing is going to happen to them. Why don't they have that basic common sense and brains to understand this can also flip, and the draconian laws that some government pushed against another, they can flip against them also. This is clearly a trial balloon, Dr. Swamy. This is my personal opinion. All this Maharashtra bill is a trial balloon for how far can we push the law and keep control over people and what they can voice. Seriously, Dr. Swamy, I have heard through channels, even many
Yes.
Supreme Court lawyers say the only man is Dr. Subramanian Swamy, who can speak against Modi. Only man, real mard. वो बोलता है, if nobody is a man, that they say, right? I mean, you
Yeah.
Ramaya in Tamil, they say that's exactly the statement being made. That Dr. Swamy, we have to thank you for where we are today. Even if we have mustered some courage, I should definitely thank you. But why do people have to be afraid, Dr. Swamy, for posting satirical comments on Twitter? People are getting booked. Some doctor in London who said something against the Modi government in Facebook lands in Bombay, gets detained for 15 hours and questioned.
My God.
I mean, this is very
Ramesh,
clear.
even Mamta Banerjee did it. Even for making a cartoon, for making a comment, professors were targeted, the students were
Correct.
targeted. I mean, as I said, all governments are guilty. I mean, I'm not
I mean,
blaming BJP
Arvindji,
or Maharashtra government only.
no, I agree. And that comes to the crucial point that Venkat made, the judiciary. Right?
Yeah,
If the
yeah.
judiciary does its job diligently and correctly, true to its words,
Mm.
all these things will automatically die. They will think twice before doing this because they say, okay, we have a pliable judiciary. I have one magistrate that is a friend when I nominated him, or something like that. So this circle is vicious. So what happens? Everything boils up to the Supreme Court when 20 years later. Like, for example, yesterday's news, Beda Patkar got the Supreme Court said she said something that was defamatory to the then Lieutenant Governor of Delhi. That got dismissed finally. It took 15 years for that to happen. It's just, as Venkat said, absolute. The judiciary, there might be a lot of good people. Again, Venkat, I agree with you, but there is. I don't have any confidence. I don't see it happening. I mean, I agree with your point that if the judiciary was more vigilant and sticking to the law and says, no, this is not right, we would not be seeing such things happening.
And don't forget Human Rights Commission. I mean, suo motu action should have been taken, or some note should have been taken by the Human Rights Commission, but nothing is being heard.
Yeah, it's a matter of time that the same Maharashtra bill can be said, or what you say, Mukoka Act. I don't know what it means. So let's say, for example, another state which has a Congress rule, or even, for example, Kerala, can determine that, okay, RSS, Bajrangal, VHP are all unlawful organizations and take action on it. They'll just say, okay, we are going to adopt the same law and throw things at you. That is also possible. Why don't they think that this can spread? And Dr. Swamy has said that there is nothing to prevent them from enacting this anywhere else.
Yeah.
This has to be challenged. And thank you again, Dr. Swamy. You're the only person who's going to jump up and do this. There's going to be a lot of, obviously, Dr. Swamy, my only problem is, you know what's going to happen? Tomorrow, BJP or some minded or bucked organization will file a bill with absolute nonsense in it and get thrown and dismissed in Supreme Court. This is with their pattern. The moment they think that a credible person can challenge a law, they'll have a decoy, a Buddhu, file a PIL in the Supreme Court and get admonished by the Supreme Court for this, and that's a dance and drama, and the Supreme Court will dismiss the plea, saying that this is nonsense. This is a pattern we have seen. It's nothing new. We are going to see the challenge also.
Yeah. Well, in that sense, what we have done today, it has got scope to grow into something bigger. So there are people watching it, they are commenting on it, and I'm getting phone calls on it being picked up by other people in my house. So yes, in during the emergency also, people thought that nobody's going to stand up. But in the end, what happened? I mean, they didn't stand up in a formal sense, but when the elections came, they defeated them so badly. Therefore, I would say that we must have faith in our past, but that doesn't mean we just say somebody else will do it.
Correct.
Whoever does it, you encourage him. That's all.
Yeah. But one difference, Dr. Swamy, between 75 and now is basically the social media and all these unnecessary things coming into play that people can just be picked up at a whim and no need to, and they don't even file an FIR. They just pick people up on the street saying that, oh, you said something against the Mahamanav. So these kind of things should stop, Dr. Swamy. I mean, grow a thick skin. Why are you in politics if you don't have a thick skin? I mean, seriously, and that's exactly where you are. You just, this is what it is. It's a democracy, and sadly, it's getting destroyed in the case of India, which was broken apart to pieces in 75, and it's just starting to revive again in 2026. Sadly, Dr. Swamy, that this is my honest thought, as sadly things are getting chipped away at. Okay, Arvindji, you can now conclude.
Yeah. In fact, let me add, it's not only Maharashtra. As I said earlier, Karnataka government has also brought a similar, not as draconian as this, but the rule to protect minorities. And UP government, even for reporting that there's so many deaths in the Kumbh stampede, FIRs are filed. So
Correct.
These are all basically to scare people not to do anything. And even if you highlight the truth, you are accused of promoting falsehood. So the governments do this, and unless this is legally protested, these things will continue. So Dr. Swamy should take initiative as he has promised, and others should follow. Thank you, Dr. Venkat Iyer. You joined us in today's program after a long time. As we know, our viewers will also know that we ran a series of legal words of wisdom, Gyan Ganga, for a long time, and you are trying to educate people on common law. Thank you very much for joining today and highlighting the key features of this draconian bill. Dr. Swamy, as always, has been forthright in saying spade is spade, and many people who are afraid. Dr. Swamy is one person, as Ramesh said, he is the only mard. He's not afraid of saying anything. And thank you, Dr. Swamy, for saying that, yes, it should be legally challenged. Thanks, Ramesh, for anchoring today. Thanks the technical team led by Ashish Shetty, Tejas Navalgul, Swaminathan, Ishwar Iyer, Gadgi Rakesh, Ajesh Nair, Gurdat Shetty. This kind of program we have been doing for last 4 years. This is 279th episode. For 2-3 months. We had a break in December, in August to December, and we are now started in the first week of January. So now we are continuing. Viewers, join us again on every Sunday 8 o'clock with a new topic. Dr. Subramanian Swamy and the speaker will be joining again next Sunday. So please join us on social media, all the social media channels, and make this program as successful as possible, and bring the public voice. This program actually raises the public voice. The issues which are dear to the public of this country are brought through this program. Thank you very much for supporting this. We'll be meeting again next week. Till then, Namaskar, Jai Hind.
Jai Hind.
Jai Sri Ram.
Jai Shri Ram.